Good afternoon, ladies and gentlemen. Welcome to the University of Arkansas Clinton School of Public Service, to another in a series of our public programs and lecture series. I am Skip Rutherford, Dean of the school, and I thank you for being here. I also thank some of you who I recognize for coming yesterday to our first annual scholarship fundraiser, which was very important as we invest in students and services here at the school. But if I could ask you to please turn your cell phones off and Blackberries and other electronic equipment, which has a tendency to interfere with the sound system from time to time. All right. I'm really pleased that our speaker would come here today. Judge Brett Kavanaugh was confirmed by the United States Senate to a position on the District of Columbia Federal Court of Appeals in May of 2006. Those of you that know the law and follow the courts know that the D.C. Circuit is second only in prestige and power. Maybe Judge Buzz Arnold might disagree with that, but it's reported to be that way to the United States Supreme Court. In fact, 4 of the current members of the court, including the Chief Justice, are alumni from the D.C. Circuit. And when you speak about the Supreme Court, though Judge Kavanaugh probably shoot me for saying this, his name is often mentioned as a candidate should a vacancy occur. He's a graduate of Yale Law School. He clerked for Justice Kennedy on the court. He worked with the law firm Kirkland & Ellis, where he focused on appellant matters, and he also served on the staff of independent counsel Kenneth Starr. Prior to his appointment in the federal bench, Judge Kavanaugh served as assistant to the president and White House staff secretary for President George W. Bush. I know his wife, Ashley. We have worked together in the planning of the Bush Presidential Library, so it's a real pleasure for me to welcome Judge Brett Kavanaugh here today.
Thank you very much, Dean Rutherford, for that introduction and the welcome. Thanks to all of you for being here today. I had a tour earlier this morning of the library, which was just fantastic to see all the effort that's gone into the exhibits there. As Dean Rutherford mentioned, my wife Ashley is working on the future library, and so I was assigned to take a few notes this morning on good exhibits and what have you at the library, and it was just a fantastic time there. The last time I was here was for the opening of the library, and I'm pleased to see that it's a little drier outside today than it was on that rainy day a few years ago, but it was a pleasure to be here then and a pleasure to be here now. That event and the library reminds us, with the former presidents and the former President Clinton and the current president and the other former presidents who are here, how we are one nation, how we're all in this together, which sometimes gets lost in public service, sometimes gets lost in Washington. It's events like the library opening and the portrait ceremony that was held at the White House for President and Mrs. Clinton by the President and Mrs. Bush that reminds us that there's a continuity through the generations with our constitutional system, with the presidents, and that we're, like I said, one nation and one people. This school, I'm proud to be here. This school is such a great example of devotion to public service and is doing a fantastic job. As I talk to people today and have been following the efforts of the school on the website over the months since I first learned I would be coming here and bringing in speakers and debates from different perspectives. I think it's just superb, and the commitment to public service. This school is about public service, and frankly, we need people to be engaged in public service. We need people who are interested in public service, who are willing to devote their careers to public service. There's so many issues through my different positions in government and in private life, so many issues that are facing our nation, so many challenges, and poverty and education and health care and the environment, where we need the best and the brightest of our rising generation to be willing to commit themselves to public service. So I applaud you, the school, and I applaud the students of the school for the commitment to public service. I also had the occasion this morning to have breakfast over at the law school with the Dean DePippa, and I really was pleased to get over there and talk to some of the professors over there. I'm teaching myself at Georgetown right now, so I was happy to go and see my fellow professors, which made them wonder what I was doing. But it was good to get over to the law school as well, and I know there's some students here from the law school. What I thought I would do is just speak for a few minutes about the judiciary and then take questions and hopefully give you some answers on any topic that you want to ask about. But I thought I would talk primarily about the judiciary. And when you come to Little Rock and you talk about the judiciary, of course, you think of the Judges Arnold and Judge Arnold, who's here, and former Judge Richard Arnold, who was also a legend in the law and a legendary jurist on the Eighth Circuit Court of Appeals here in Little Rock. And, you know, really the best and the brightest as I look to people who were on the judiciary in the past, on this circuit court, on the DC Circuit Court, people like Judge Arnold, who were scholars and gentlemen and great jurists. And I think, how do we continue as a system, as a constitutional system? I've been involved in the executive branch in this. I'm now a judge, to continue to attract people like the Judges Arnold to the federal bench, because the federal judiciary is really, as I said many times, as I said at my confirmation hearing, I think it's one of the crown jewels, if not the crown jewel, of our constitutional democracy. And it ultimately depends on getting good people willing to become judges in our system. So how do we do that? I'm worried about it. Others are worried about it, continuing to attract the best. The first thing I want to emphasize is that our system needs to continue to look for people who are interested in being judges, who have been involved in public service, who have been involved in politics, who've been involved in government, who've been involved in controversial issues. Throughout our history, from John Marshall to Byron White and Robert Jackson, people on the Supreme Court, we've looked for people who've been in the arena who become judges. And I think that's a great tradition in our country. It brings great insight into how the government works, which is really important for members of the judiciary, and it brings a whole lot of practical experience to the judiciary. So one important part of our system is we're not the European system where you get out of school and you train from school onwards to be a judge. That's not our system. Our system throughout our history has been one where we attract judges from all walks of public and private life. And I think it's really important that we not disqualify people because they've been involved in difficult public issues, because they've served in the Senate, because they've been involved in the executive branch. And there's a corollary to this that's important for the private sector as well. You should not be disqualified because you represented controversial clients or had to take positions on behalf of your clients that were difficult positions. That's the job of an attorney. That's what we want our legal system to do. We don't want people to be thinking from age 22, oh, well, I'm not going to represent that client because that might affect my chances of becoming a judge someday. We don't want people shying away from that. It's really important for our system, our Senate confirmation system, our judicial nomination process at the federal level to continue to attract people who've been involved in public life and not to disqualify people because of the clients they've represented. You know, you look at someone like Justice Ruth Bader Ginsburg, who did such great work in her legal career representing women's rights issues and really was a crusader for that issue and then became a judge. You know, that's the kind of person, or John Roberts, who worked so long in the executive branch in the 80s and 90s in the Solicitor General's office and had to take controversial positions. People like that, we need to continue to remember our history and that people aren't disqualified for those kinds of representations. The second point, so the first point is, you know, continue to attract people who have been involved in those kinds of issues and not disqualify them. The second point is our confirmation process, particularly at the appeals court level, continues to be broken. It's still broken. It was broken when President Clinton was president. It's broken with President Bush as president. And the American Bar Association, former Chief Justice Rehnquist, President Clinton, President Bush have spoken about this on many occasions. And The reason it's a problem is not just because the process itself and it bogs down Washington and people get caught up in it, but it's a problem because, like I said, we want to continue to attract people to the judiciary who are at the top of the profession. Well, people are shying away from it. People don't want to go through a 3-year confirmation process. People don't want to have their lives dragged through the mud in the way that the confirmation process works now. And sometimes people go through it for many years and never even get a vote at all. And again, this is a bipartisan issue. This happened to too many of President Clinton's judicial nominees. It's happened to too many of President Bush's judicial nominees. So what's the solution to that problem? And I think the solution is for the executive and the Senate, and with the judiciary's encouragement, since it does affect the judiciary, to come together and agree on a process, on timelines. The biggest problem is that the process doesn't come to an end. People get held up for years as judicial nominees without ever getting a vote. And so to agree on timelines from the time you're nominated to the time you have a hearing before the Judiciary Committee, the time that the Judiciary Committee votes, and the time that the full Senate votes. This, whether it's 1 year from nomination to final vote or it's 6 months, there needs to be some process put in place. And again, this is both so the process is more orderly, so the judicial vacancies are filled, but my more long-term concern is, again, to continue to find people who are willing to put their lives and careers on hold during this confirmation process. It's a painful process. I can certainly testify to that, and it's difficult for your family, and no one likes to go through it, and when you have to go through it for multiple years, then your friends say, I'm not going through that. Why go through that? And that's really harmful in the end to the judiciary. I think timelines would help solve the problem. Now, there are a couple issues that, of course, would have to be taken into account in timeline, even if timelines were imposed. For example, traditionally, home state senators' views have been predominant in the process. So if you're a judicial nominee from Maryland and your home state senator from Maryland doesn't support you, usually that's prevented you from ever getting a hearing. So that would have to be factored into the process, of course, as an exception to what I outlined. That doesn't happen very often, but when it does, that would have to be factored in. And of course, there's debate about filibusters and how filibusters should work in the Senate confirmation process. And on that, the Senate seems to have come to a rough compromise over the last few years that filibusters are generally inappropriate, but that they will be allowed in extraordinary circumstances. Extraordinary circumstances is not defined, but again, as long as there's agreement ahead of time on the rules and the fact that there will be an end to the process, a 60-vote margin is required to get over a filibuster. So at least if there's agreement, you'll get that filibuster vote. It's called a cloture vote in Washington speak, within 6 months of nomination or within a year of nomination. At least there's a certainty to the process, and that will encourage people to be involved. I mentioned extraordinary circumstance. I've never been so pleased in my entire life to have so many people say, you're not extraordinary. There's nothing extraordinary about you. You are so ordinary, I can't even believe it. Which my senator supporters were saying to me. Some of my critics were saying I was plenty extraordinary, but that's the way the filibuster process works right now. The third issue that I want to mention in terms of continuing to attract people to the judiciary is one that is unpleasant to talk about, but it's judicial pay. And there's a real problem with public service right now. It's not just limited to the judiciary. Of course, people want to go into government generally. Teaching, of course, it's long been a problem, the teacher salaries. But it's a real problem right now for attracting judges because the disparity between what judges make, federal judges, and what people in private practice make is becoming, instead of this, it's over time becoming this or this. And it gets harder and harder to attract people to the judiciary, knowing what they have to give up in terms of salary. When your law clerk, as my law clerks are now, going out into the private sector and making more within 1 year than I make, it tends to suggest a disparity, to suggest a problem. And so the Chief Justice, along with members of the House and Senate from both parties, are really making a big push to increase judicial pay. It's a problem also, not just with attracting people, but we've had a large number of judges leaving too many in recent times, more leaving the bench, and that's a problem both because we lose that experience from the judiciary. There's an excellent district court judge in Utah, Judge Paul Cassell, who just announced he was leaving the bench after 6 years. He's a real expert on sentencing law and it's been a real contribution to the judiciary, but he's leaving because he's got a large family and he can't afford it any longer, he said. That's a real problem when we lose people like that from the judiciary. It's also a problem, the last thing I'll say about the pay issue, it's also a problem because you don't want, we're there for life. I'm a lifer on the DC circuit. I plan to be there for 40 years, hopefully, and you don't want judges making decisions thinking, say, a business case, thinking, well, how's this going to affect my job interview 5 years from now when I've decided I've had enough and I want to go get a job at this company. You don't want judges thinking about antitrust cases that way or thinking about criminal investigation cases. You just don't want judges. Judges are independent, and independence comes from life tenure along with pay protection, and you don't want judges thinking about future job prospects. So all those rationales are supporting the Chief Justice's current effort to increase judicial pay, and there's progress being made, and hopefully that will come about in the near future. I want to also just say a word before the Q&A about judging, what judging's like, what it's like to become an umpire, as the Chief Justice memorably called us in his confirmation hearings, in an era of partisanship, an era of extreme partisanship, one might say. And I know I read that Judge Richard Arnold once said that when he was asked after his confirmation, he's not a Democrat, he used to be a Democrat. And that really describes well what I think happens when you become a judge. You may have been involved in all sorts of issues in the past. You may have been involved in politics, you may have been involved in certain causes, certain issues that you were part of that you really worked hard on for your career. But once you become a judge, you're an umpire. You're no longer a partisan, you're no longer a policy advocate, you no longer have a social or policy agenda. Your job is to call balls and strikes. And as the Chief Justice also reminded us with respect to judges, no one ever bought a ticket to see the umpire. And that typically witty comment by the Chief Justice, I think, demonstrated his vision and a vision that a lot of us in the judiciary share about our role in the overall process. I like to tell people that the culture of judging, and on my court, and I think on many of the federal appeals courts throughout the country, is a culture of humility and modesty and civility and collegiality and ultimately neutrality. That's what the culture is. That's what the culture of judging should be in our system. And when I say those terms, that's both stylistic and substantive. And what do I mean by stylistic and substantive? Well, in the stylistic part, this culture of neutrality and civility, we wear black robes. That's to show that we're part of a system, part of a neutral and objective system that's larger than what any one person, and represents our objectivity in the process. We don't have TV. We're not there preening for the cameras. We don't have TV in the courtrooms. Our job's to decide cases based on the law. We're not supposed to be personalities. We're not supposed to be advocates. We're not supposed to get out there in the public and become like political candidates. We hear oral argument in panels of 3 at the federal appeals court level. Again, panels of 3, no one judge. As district court judges like to remind me, there's no one less powerful than a single appellate court judge. Since we sit in panels of 3, we can only do things if we have someone else who agrees with us. And that's the process of collegiality that I talked about. We write our opinions. We hear oral argument with judges, and we write our opinions for the public and the litigants to see. We can't make our decisions based on just who we like or who we thought was the best advocate in the case. Our job is to base the decision on the law in the case, on the law as presented to us, on the precedents that we have from our court, and to do so in a written opinion where we explain our reasoning and are persuaded our colleagues on the panel and convinced our colleagues on the court more broadly that the case is correctly decided. And so we have a process that we go through, and that process again, when you become a judge, you buy into this culture, like I said, this culture of neutrality. And this has substantive effects too, I think, when you think about our role. Our job, as I said, is to call the balls and strikes. Our job, and particularly at the appeals court level, the Supreme Court level, we can talk about that during the Q&A, but at the appeals court level, our job's really to call the balls and strikes. We're not there setting the strike zone. We're not saying make the strike zone narrower or make it wider. Our job's to fit the case within the precedents that we have, within the statute that Congress has passed. Our job, in my judgment, is to follow the words of the Constitution and the statutes and the contracts that are before us, not to enforce or impose our own policy views on a particular case. We're not in Congress. We may have served in the executive branch, but it's not our job to be pro-executive or pro-criminal defendant in a particular case. It's our job to assess it. Some of us might have been criminal defense lawyers, but we approach each case with the necessary objectivity. And by following the words of the Constitution, the words that are written there, the words of the statute, by following the words of the contract, ultimately, when we do that, we're not pro-business judges or pro-labor judges or pro-environment judges. We just follow the words as they lead us. Some statutes are written broadly in a pro-environmental way. Some might be written broadly in a pro-labor way in a labor relations case. Some might favor business interests more in the particular case. But our job is to follow the case regardless of who the winner and loser is. Again, it's like the umpire. It doesn't matter who the winner or loser is. It doesn't matter which teams are playing. It's our job to call it the same every time around. And this is, again, part of the culture. We're not social or moral policy engineers. We can't be. We're not elected to do that. We're not accountable for that. We don't have the authority, for the most part, except to the extent it's imposed in precedent, to do that. And so we can't be the people who are going to make the big policy decisions for the country. It's, again, our job to enforce the terms of the Constitution, to draw the limits within which Congress can operate and the executive branch can operate. But we don't make the decisions about which policy direction the country should head. And all of this together, all the points I've talked about so far, are really designed for an ideal of judicial independence. The idea that we attract good people, that we retain them on the bench, that we participate in a process that involves written opinions with life tenure. It's all designed because we're to preserve the ideal of judicial independence in our country. Judges that are not influenced by political considerations or policy considerations, but just are there to say what the law is. And I know that's somewhat criticized as being somewhat simplistic, and sure, they're tough cases. They're tough cases where the ball's right on the line of the strike zone. But if you keep that vision in mind as a judge, at least I've found in my short time on the bench, I think we live up to the role that the founders envisioned for us, and I think we live up to the role that the American people today expect for us. Again, the role of a judge is to be an umpire, and I'm doing my best to do that, and I thank you all for listening to me today, and I look forward to your questions and answering them to the best I can. Thank you again.
Okay, anybody got questions? We got one right over here. Dennis?
I was talking yesterday to someone who was involved in the Attorney General issues. Mm-hmm. Their opinion was that it was all politics, that if the Democrats hadn't come into power, there never would have been any subpoenas to do anything, nothing ever would have shown up, and just nothing but politics. Your comment about the appellate court situation is about politics. That's holding up all these issues. Mm-hmm. One, do we need to take politics out of the judicial system more than what it is? And two, is the Attorney General situation just a political issue, and nothing else, and we don't need to worry about it? Or is it truly that it is the reason it is a problem, it is about politics?
Well, let me address the issue of the judicial confirmation process first. I think at the appeals court level, what's happened is there's been people who've been held up years ago, and no one can really remember who started it the first time around, and it's gotten so bad. And what's happened is there's been payback. So, for example, at the end of the first Bush administration, just as a case study, John Roberts had been nominated to the D.C. Circuit Court of Appeals in January of 1992. And he never got a hearing or a vote, and he did not get confirmed to the D.C. Circuit at that time. Then President Clinton came in, and he had some nominees who were confirmed to the D.C. Circuit, but he also had some others that never got a hearing or a vote. And one of the mantras of Republicans at that time was, remember what happened to President Bush's nominee. And then you fast forward to the current President Bush, and he's had some nominees to my court other than myself, including some who haven't gotten through. And part of the rationale has been, well, there were some of President Clinton's nominees who didn't get through to that court. So it ultimately has been a lot of payback in the political process, and I think that's been a large part of the problem. Now, people debate, when did this all start? Throughout our history, Supreme Court nominations, of course, have always been vigorously debated, at times controversial. It's a political process in the sense that the Senate is involved and the president's involved in the nomination and confirmation. But I think what's happened is that it's seeped down to the appeals court level, and what's happened is just a lot of political payback. Instead of recognizing that we're looking for the best lawyers we can find who are willing to serve on the appeals court, people are being penalized for positions they might have taken, for clients they might have represented, for issues they might have been involved with, or for people with whom they've associated through their career. So there have been penalties that have been imposed on people, political penalties. And I think the process should be rigorous and vigorous, the judicial confirmation process. Like I said, I'm there for life, so it should be rigorous and vigorous, because that's a hefty responsibility. But it should come to an end at a time certain. There should be a time to debate and come to an end so that we continue to attract people. And so in terms of is there too much politics in the process? I don't know what too much is. It's got to necessarily go through a political process, but if it comes to an end at a time certain, I think that would be very useful for the judiciary, it'd be useful for the Senate, it'd be useful for the presidency, regardless of who controls which branch and what have you. Now, in terms of the judging, during my confirmation process, one of the interesting things was I went around and met with individual senators, about 20 of them, because my vote was going to be on the margins, so we were really pushing hard to go meet with individual senators and let them get to know me. And when I met with Senator Schumer, who was someone who had been pretty critical of me at the first hearing, I met with him one-on-one, and it was very interesting. It was fascinating. We met for about an hour, and we had a lengthy discussion about how judges decide cases. And the vision that I outlined in my remarks about being an umpire, he just doesn't share that vision of that it's actually how judges decide cases. He thinks judges decide cases that, in close cases, political considerations come into play, or policy considerations. And I tried to convince him that that wasn't my experience when I was a law clerk for Justice Kennedy or for Judge Kaczynski or Judge Stapleton. That wasn't my experience as a litigant. That certainly wasn't my vision of the role I was going to perform as a judge. But there's an element, I think, on both parties. Again, this is not a partisan issue, it's a bipartisan issue in the Senate, that just believe judges in close cases just kind of go with their political leanings. And so part of why I focus my remarks on that, part of what I want to do over the course of my career, to the extent I speak, is to explain to people that judging is different from politics. It's got to be different from politics. It's different from policy, and we have to convince people that it is, and we have to find people for the bench who really believe that to their core, the way that so many judges throughout our history have shown us. So on the second issue, I think I'm going to be careful about answering a question on the second issue. I know a lot of the people involved, and as a judge, I'm probably the last person who should be commenting on the back and forth. It is typical, of course, for the House and Senate to inquire, exercise their oversight power over executive branch agencies. This is part of that process. It's a messy process. It's part of accountability for the executive branch. But beyond that, I probably won't comment on the specifics.
Julie? Wait for the mic.
Surprised when the current President Bush stopped using the ABA process.
Yes.
When he first came in, but they've gone back to that now, haven't they?
Well, let me explain that. It used to be that the president would send a prospective nominee's name to the ABA before the actual nomination had been made. So you know, John Doe, you send the name to the ABA, they come back confidentially and give you an evaluation, the president or the White House counsel, the attorney general, and then you make the decision whether to nominate. What President Bush said is that he thought it was improper, he said, to give a single organization that kind of influence over the judicial nomination process. And he thought that was improper in terms of favoritism of one group, particularly a group that was involved on a lot of controversial issues, a group that takes positions on issues before the courts. And so he said that he didn't object to them rating the nominees after they're nominated, but he objected to giving them a preferred position in the nomination process. So what happens now is they rate the nominee after nomination. So when you said they're still involved, they're involved after nomination, and you'll see the ratings still come out. And that's how that changed and how it works. There's still a lot of controversy, I might add, about the ABA role in the process. Because the Senate pays great attention to what the ABA ratings are. But that controversy stems from incidents long ago, usually, and I don't know if the people who hold the particular views on that feel them very strongly, and I don't think it, like I said, it's really historically based. In any event, the process still continues after nomination.
Okay, Annie?
Say two things. One is this school renders public service by its very existence.
Yes.
It develops leaders for the future, but it also provides an opportunity for the citizenry to be informed. And that's what you have done today, is to bring some additional information. My question is that I know that the Constitution provided for the three branches of government as checks and balances for democracy to work. Now we begin, as the evolution has come, that there is, in some people's mind, there are the three plus the media plus the lobbyists, who were formerly one of those other three branches. And I'd like to know, what is your feel about the lobbyists and the media's impact on human beings who are going to be judges? What is the impact
Lobbyist
on human
impact
being that is being considered for the judicial with this evolution that we're in the 21st century?
Let me explain my reaction to that in a couple of ways. First of all, in terms of the media, obviously the media has a critical role in our constitutional system in holding everyone to account. And in the confirmation process, they play a particularly important role, especially at the Supreme Court level, of ferreting out information about the person's past, exposing things that the person has done in the past, for better or for worse. But the media is the engine of often uncovering things, and that's always been the case in our society. And you know, the First Amendment protects freedom of speech, protects freedom of the press, and certainly the media exercises that power aggressively, as it should, frankly, to hold people in government accountable. So what I think has changed is that there's really been a development with the role of blogs in the judicial confirmation process. And I think with Chief Justice Roberts and Justice Alito's confirmation process, you saw, at least in Washington, much more rapid allegation and rapid response occurring on blogs than we'd ever seen in judicial confirmations in the past. And I think that's something new, and I think frankly, the administration and the defenders of Chief Justice Roberts and Justice Alito did a very impressive job of rapid response defense of the two of them. So there would be something written about, Chief Justice Roberts, what he had done as an administration lawyer for the Reagan administration in 1982. Well, before noon, there'd be a full response on a blog, really responding to it, putting forth the contrary view, addressing any concerns, putting it in context. So this rapid response, I think, was something that was new in the confirmation process and something that was very helpful, in this case, to the nominees. One could imagine that it would be harmful to the nominees if the blog opposition develops over time, which it certainly could. But in this case, the defenders of Chief Justice Roberts and Justice Alito really made effective use of it. In terms of the lobbyists, I would say this. I think the role of interest groups, which I did not mention in the confirmation process, is somewhat distorting. What do I mean by that? There are interest groups out there that are devoted to issues, as they should be. So I'm a Chamber of Commerce lobbyist, or I'm an environmental lobbyist, or I'm a lobbyist for workers' rights. And what I care about is getting judges on the courts who are going to favor my position, right? I'm not really looking for judges who interpret the law in some particular philosophical way. I want judges who are sympathetic to my point of view. And so what happens is interest groups tend to infect, I would say, the Senate process at times with looking at the judicial process as all about results. It's all about, okay, is this judge going to be pro-worker or pro-business? Well, that's not the right question. The right question is, will this judge interpret the law in a way that's pro-worker when the law is written that way, and will this judge interpret the law that's pro-business when the law is written that way? That's really what the question should be. And I think what happens is interest groups, and particularly, on hot-button issues, drive the confirmation process into looking at judges as a series of results. So what happens then is judges are we're just looked at then as just politicians in robes, which is contrary to everything I believe about the judiciary and how we should operate and how we largely do operate. And so that's lobbyists for interest groups, I think, do First Amendment, great service in terms of legislation and representing their positions, but it has a distorting effect on the confirmation process at times that I think's troubling.
Questions? Professor Tucker, you got any law students that have any questions to ask right here? Put the law students on the spot.
Judge, thank you for coming here today.
Thank you.
You were talking about how people get disqualified for various reasons that they may not necessarily should be disqualified for. It seems that a trend recently, particularly for Supreme Court justices, is that you pay a penalty if you didn't go to Harvard Law School or Yale Law School. No offense to you personally, but I was just wondering if you could comment on that and see where you think that might be going in the future.
I didn't hear the last part of the question, I'm sorry.
Just what your comment on that is and if you see that trend continue.
The trend toward?
Just nominating judges to the Supreme Court who went to basically only Harvard Law.
Harvard,
Yale Law.
yeah, it's mostly Harvard.
Yeah, it's mostly.
I think that's just circumstance, I would imagine, but because you look at the last, let's just say President Clinton's 2 Supreme Court nominees and President Bush's 2 Supreme Court nominees as a case study. All 4 of them are just unbelievably well qualified for the Supreme Court in terms of their experience, in terms of their intellect, in terms of how well they'd done at law school, in terms of the respect they'd engendered from all sides of the political spectrum for judging over the years. And so when you look at Justice Ginsburg and Justice Breyer and Justice Alito and Chief Justice Roberts, it was really, the top, along with a few others, but they were at the top of the federal judiciary. And so I don't think it was really, I would say it's not a law school issue. What it is what I think is probably a good trend in terms of the judiciary is excellence rising to the level of the Supreme Court. And I think that's a healthy thing to see and certainly consistent with what I was talking about, what we want to do and continuing to attract people like that who are interested in becoming judges in the first place. What if 30 years ago, a Ruth Bader Ginsburg hadn't gone on the D.C. Circuit Court of Appeals, either because someone said, oh, she's argued too many controversial cases, we're not going to go for her. You know, that would be terrible. Or Justice Breyer, who had worked on the Senate Judiciary Committee for many years as a staffer, and so had been very involved in political issues and policy issues. If someone had said when he went on the First Circuit in 1980, no, we can't put him on, he's too political. Or John Roberts when he went on the D.C. Circuit, oh, he represented this client and that client, you know, and we're not going to put him on a court. He's been too involved in representing parties. He can't be neutral as a judge. You know, those kinds of things would have been very problematic in terms of the confirmation process. But all four of them are what you would call excellent in terms of their records, their qualifications, and I think represent the best and the brightest of the appeals court judiciary that were then nominated to the Supreme Court.
In the spirit of full disclosure, Judge, Professor Tucker graduated from Harvard undergraduate and came back to the University of Arkansas Law School. So
yes, yes.
He may have had some
Trick question.
He may have had some ulterior motive in that question.
Trick question.
All right, now, we got a question right here.
I just wanted to throw out some thoughts and get your comment on them. You talked about the restrained role of the judiciary and judges shouldn't be politicians in robes. And you also talked about how the temperature of confirmation hearings has been turned up. And I wonder if part of the reason that the temperature's been turned up is because we got a lot of politicians in robes in the past. Yeah. The Warren Court, almost none of them had any prior judicial experience. The current Supreme Court, they all do. And you've also talked about how people shouldn't be limited from becoming judges based on what they've done in the past. I wonder if you could comment on the concept of legislators as judges or people who have been in roles that involve them in policy in such a manner that that they need to have some form of experience to learn about judicial restraint prior to being put in a lifetime position of responsibility.
In terms of your first question, the first part of your question, in terms of they've seen the Supreme Court or the courts operate in the past beyond their role, I think that's true. I mean, that's some senators say, well, what about this decision and that decision? That clearly wasn't judges as umpires. Don't tell me that judges are umpires. So, you know, that is a problem over time that is hard to overcome when you're trying to convince people that the proper role of the judiciary should be and is to just decide cases neutrally. And there's no doubt that that's sometimes fighting a battle to recover from a legacy where people saw some decisions as being too activist on both sides. Again, this is a bipartisan issue. I don't think it's a partisan issue. In terms of the legislators becoming judges, I think that the spirit of my comments was that we should look for people from all walks for the judiciary, particularly at the federal appeals court and federal district court level. I think at the federal district court level, it's important for people to have some trial experience because that's a very, you know, if you've never done a trial, it's hard to become a federal district court judge. But at the federal appeals court level, I think we should be welcoming people who have great experience in the legislative branch, who've worked in the executive branch, have worked in different parts of the process. For the Supreme Court, you know, that's really not for me to say, but certainly I can describe what's happened. I think what's happened is really a reaction to what you described that went on, you know, 50 years ago or 40 years ago or 30 years ago when people were complaining, or 20 years ago, people were complaining about judges being beyond their role. And so what's happened, I think, is a recognition that the Supreme Court's there to decide legal cases, not social policy for the country. And the best way for presidents of both parties, it appears, to determine whether the prospective nominee meets that vision of their judicial philosophy is someone who's demonstrated it over time. We were talking about this at the law school. I was talking about it with a few of the professors earlier today. It's tough to send someone onto a court, especially the highest court, who's never been a judge before, and ask them to know all the culture. You know, I talked a lot about the culture of civility and collegiality and neutrality. Well, you learn that over time from being a judge, and it's tough, I think, at the Supreme Court level to ask someone to just pick up and have that, and certainly the nominations, all 9 the current Supreme Court justices have prior judicial experience.
We've got time for one more question. Professor, you're going to try to rehabilitate yourself?
I'll just follow up on Dave's question. So, I mean, you know, Hugo Black was a senator before he was a Supreme Court
Yeah.
justice. I mean, do you think the days of that are over? I mean, I know there were some senators on the short list when Justice Alito was nominated.
I don't think the days of that are over. I'm just saying that the trend certainly appears to be that presidents and the people who advise presidents and senators and the people who advise senators seem more interested in getting a known commodity in terms of how you approach the job of judging before you entrust them with a job in the highest court in the land. I think Hugo Black is an interesting example because I think he's one of the real heroes of the judiciary in terms of how he was someone who really demonstrated that neutrality principle throughout his judicial career, someone who was very much follow the words of the law to the point where he disagreed with his colleagues on occasion, saying it says Congress shall make no law abridging the freedom of speech, and he applied that principle across the board in a variety of areas, and someone who had come from the Senate. So it's certainly possible, and certainly history shows us examples of that on the Supreme Court, but the trend does seem to be more to the judicial level. I don't think it's over, though. I think, you read the stories, and you never know how accurate these are, but the stories of presidents in recent times who have looked for people who have been served in the legislative branch as senators or who have served as governors to become Supreme Court justices. It just hasn't, in the end, I think that the tipping point has been, well, this is a known commodity. They've demonstrated they're the best of the judiciary. When you've done that, that makes the confirmation process a whole lot easier because they've excelled on the judiciary for many years. So I think that explains the trend.
Let's say thanks to Judge Brett Kavanaugh.
Thank you.